Hello friends, in the series on the income tax cases, today we will discuss a very important issue on the evidentiary value of a statement which is taken at the time of survey and at the same time the mannerism in which a document is to be read at the time of making the additions or whenever a document is relied on for any purposes. This issue has been taken by Ahmedabad ITAT D bench in the case of income tax officer versus Shubh developers, and this case has been reported in 109 ITR Tribunal short note 61, and the date of the judgment is 5th January 2024. The facts of the case are very interesting. In the present case, a survey was conducted on an Assessee, which is a partnership firm, on 3rd September 2013. As all we know, whenever there are survey search, there is a inherent practice on the part of the department that the department is very eager to take the statements of different persons at the time of the survey or search, and in spite of collecting the evidences, their main thrust is to get the income surrendered by the way of statements taken from the assessee, because this is a very easy job for them. Although there is a CBDT circular regarding the statements which categorically mentions that at the time of survey or search, the department should not take the statement by coercive methods, and in spite of admitting into the statements, it should be the endeavor of the revenue that they should try maximum to collect the evidences in spite of getting the income surrendered through statements. The reason of this circular is that because in the courts, when the matter goes, the courts says that the statements can be relied only if they are accompanied by the sufficient evidence. In the present case, when the statement of the two partners were taken, because the assessee was into the construction business, the two partners somehow admitted at the time of survey in their statements that a profit element of 3.51 crore has been escaped from including the computation of income of the assessee on the different projects. When the assessment was going on near about 1 year and 3 months, that is on 8th December 2014, the assessee retracted the statement of the two partners along with affidavit. When this statement was retracted, the assessee also submitted the completion detail of all the projects, the corresponding profit element in those projects, and the year in which that profit has been taken into the income of the assessee. The assessing officer did not rebutted, did not challenges that computation sheet given by the assessee, and in spite of that, the assessing officer declined to entertain the retraction statement simply on the ground that it is self-serving, because this is the easiest job for them to reject anything by some standard templates. When the matter came to the CIT appeal, CIT appeal gave a very balanced judgment in this case and said that in the present case, from the evidences which the assessee has given, it is very clear that the assessee has taken the income which is arising from the projects at the rate of 8% already into his income, and just for the sake of any leakage of the revenue, he restricted the addition to a moderate percentage of 12.5%. The department challenged this order, and when this matter came to the tribunal said that first of all, whatever the statement is taken during the survey proceedings, that statement is not on oath, so that statement cannot be relied 100% in the absence of sufficient evidence, because the statement without oath does not have any evidentiary value. Secondly, the tribunal said that whenever a document is read, it should be read as a whole, and it is not permissible in law that the assessing officer do accept a part of the statement or a document and reject the remaining part. So, by giving these concluding remarks, the tribunal sustained the order of the CIT appeal and dismissed the appeal of the revenue. So, from the conclusion of this case law, it is very clear that if some income has been admitted into some statements by some coercive action taken by the department or by some nervousness at the time of giving of the statements, so that statements do not hold good for making the assessment of the assessee. At the end of this video, once again I am repeating the name of the case. The name of the case is Income Tax Officer versus Shubh Developers, and this case has been reported in 109 ITR short note 61, and the matter has been decided by Ahmedabad ITAT D bench, and the date of the judgment is 5th January 2024. Thank you, friends.